Hello there. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. So I want to thank you for watching our YouTube channel. And today I want to talk to you about unequal contributions when you purchase a home with someone else. So at a time of record home unaffordability, more people are teaming up with friends and relatives to realize that home ownership dream. According to the National Association of Realtors, more than 75% of homes on the market are just too expensive for middle income buyers to purchase. Now, just 5 years ago, the same income group could afford half of all available homes. From 2010 to 2020, the number of homes bought by people with different last names soared by more than 770%. Now, this group includes friends, roommates, and married couples. In 2021, the percentage of single-family homes purchased by non-married co-buyers was 25%, and it was only 17% back in 2018. Purchasing a property with other people can help a buyer to lower their individual cost while still building equity. However, going in on a house together can also create some troubled spots, including survivorship and inheritance issues. Now, a home is the largest single investment that most people will make. When buying a home with another person, the co-owners must decide how to hold the title so that it aligns with their wealth building and estate planning goals. So let's begin by talking about co-ownership and home titles. Co-buying a home with a partner, a relative, or a friend can reduce the cost of the down payment, the mortgage payments, utilities, and other household expenses for each buyer, while still allowing them to build home equity. Some co-buyers may not even want to live in their home. Their goal may be to rent it out or to flip it for a profit. Now, home co-ownership can present problems as well. If one buyer has a bad credit score, it can negatively affect another buyer's mortgage terms. And if one party cannot meet their financial obligations, the other party could be on the hook for that budget shortfall. Now, typically, co-owners are not only listed together on the mortgage loan, but on the home title as well, or the deed. Having more than one person on that deed or the title raises estate planning issues that may not immediately arise, but should be thought about. Now, property can be titled in different ways. Common ways of joint ownership titling include tenants in common, joint tenants with right to survivorship, and tenants by the entirety. Let's first look at tenants in common. With this type of title, property shares may or may not be divided equally between owners. Each owner's share might be equal to their investment in the property, or the shares may be divided equally among the owners. However, the co-owners still have equal rights to use all areas of the property. They can also choose who receives their interest when they die, as it does not automatically pass to that other owner. Now, joint tenants with right to survivorship. Under this type of arrangement, each owner has an undivided interest in the property. They own the property in equal shares and have the right to use the property however they wish. The right of joint right to survivorship means that when one joint owner dies, their property interest passes to that other surviving joint owner. Now we have another type of ownership called tenancy by the entirety. This title option works the same way as joint tenants with right to survivorship, but is only available to married couples in certain states. It also provides valuable creditor protection because property owned in this way is not subject to the creditors of just one spouse, although it may be subject to the claims of a creditor of both spouses. Now, in states with community property, another type of joint ownership for married couples, co-owned property can be titled with the right of survivorship, but it is not the default and must be designated this way. So we also need to talk about joint ownership and estate planning. Around 60% of Americans do not have a will, but the percentage without an estate plan is highest among millennials, about 78%, and lower among baby boomers, where it comes at about 58%. About 2/3 of Generation Xers do not have a will, while more than 80% of those aged 72 or older do have a will. Now, one of the top reasons cited for failing to address estate planning is a lack of assets to leave to anyone. While this is often a myth, estate planning is advisable no matter how many assets a person has. And buying a house instantly changes that. For most people, a home is their greatest investment and the primary driver of household wealth. Even if somebody co-owns a house, their investment in the property is likely to dwarf their other accounts and property. Deciding what to do with shares of jointly owned property is a major estate planning consideration, and it begins at the time a property is purchased and the title is issued. When co-buying a house, each owner should understand how it is being titled and make sure that the titling matches their estate planning wishes. For example, joint tenancy might make sense for a married couple, but be a poor choice for friends or unmarried partners, because they will have to give up the right to leave that property to one other than that co-owner. Now, in the latter case, tenancy in common is likely a better option. Each tenant in common has the power to dispose of their property interest however they may choose, but only if they indicate their wishes in their estate plan. Otherwise, their share of the property passes according to state law when they pass away. For those who already own a house, how the property is titled is no less important to their estate plan. Circumstances change. The original title terms may no longer reflect a person's current priorities. While changing a joint tenancy may not always be possible or practical, at the very least, a person should know how a home title affects their property rights, the rights of any heirs, and their tax obligations. So you really want to get your estate planning house in order. Choosing how to title a co-owned home and how this choice fits into your estate plan depends on the people and the property involved, your estate planning goals, and state laws where that property is located. An estate planning attorney in the state where you live, if you're in Mass or New Hampshire, we're happy to help, or you can seek advice from an estate planning attorney in the state in which you live to explain the pros and cons of each type of home ownership. So I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law, and please like and subscribe below if you want to hear more about estate planning and how it can benefit your family.